Mr. Beat presents Supreme Court Briefs.
Clayton County, Georgia, January 2013. Gerald Bostock, a gay man, joins a gay-focused recreational softball league. Bostock had been a child welfare services coordinator for the juvenile court of Clayton County for a decade at that point, and he made the apparently fateful choice of promoting the gay softball league at work. After this, Bostock began getting criticized at work, not only for participating in the softball league, but for his sexual orientation. In April, Clayton County audited the program funds controlled by Bostock and then promptly fired him for, quote, conduct unbecoming a county employee. Well, Bostock thought this was just an excuse for the county to fire him for being gay. That said, Georgia had no law protecting LGBT plus people from employment discrimination at the time. Bostock thought it over for around 3 years before finally filing a claim for workplace discrimination in the U.S. District Court for the North District of Georgia. He claimed that Clayton County went against Title VII of the Civil Rights Act of 1964 when it fired him. However, the U.S. District Court for the North District of Georgia dismissed the claim, saying that Bostock's claim was based on a fairly loose interpretation of Title VII of the Civil Rights Act, saying that Title VII didn't include protection against discrimination towards sexual orientation. It even used the U.S. Circuit Court case Evans v. Georgia Regional Hospital as precedent to back up its decision. Bostock was like, nope, and then appealed to the same court that made the decision in Evans v. Georgia Regional Hospital. As a matter of fact, the U.S. Court of Appeals for the 11th Circuit. As you may have already predicted, though, it sided with Clayton County and cited the Evans decision as precedent. However, things got complicated when other circuit courts weighed in on the same legal issue, leading to what's known as a circuit split. In the case RG and GR Harris Funeral Homes Inc. v. Equal Employment Opportunity Commission, woo, that's a long title of the case, the U.S. Court of Appeals for the 6th Circuit found that a transgender funeral home worker was protected under Title VII of the Civil Rights Act from being fired for her gender identity. On the other hand, the U.S. Court of Appeals for the 2nd Circuit did say that employers can't discriminate based on sexual orientation in Altitude Express Inc. v. Zarda, a case involving a gay skydiving instructor. Because of the circuit courts being split, the Supreme Court agreed to step in to look at all three cases, combining them and hearing oral arguments on October 8th, 2019. The big question they had to consider: does Title VII of the Civil Rights Act of 1964 prohibit employment discrimination based on an individual's sexual orientation or gender identity? The court said yes. On June 15th, 2020, it announced it had sided with Bostock and the other employees discriminated against. It was 6-3, with the typically right-leaning Chief Justice John Roberts and Justice Neil Gorsuch siding with the more left-leaning justices. The court said it was illegal for employers to fire employees for being gay. Not only that, it said it was illegal for employers to fire employees for being transgender. Neil Gorsuch actually wrote the majority opinion saying, quote, an employer who fired an individual for being homosexual or transgender fires that person for traits or actions it would not have questioned in members of a different sex. He added, quote, those who adopted the Civil Rights Act might not have anticipated their work would lead to this particular result, but the limits of the drafter's imagination supply no reason to ignore the law's demands. Only the written word is the law, and all persons are entitled to its benefit. Bostock v. Clayton County was a huge victory for LGBT plus rights in the United States. More than any other Supreme Court case in history, the Bostock decision made it clear that if an employer was going to discriminate against an employee based on their sexual orientation or gender identity, they would be breaking the law. The Clayton County Board of Commissioners ultimately paid Gerald Bostock $825,000 in damages for his wrongful termination. I'll see you for the next Supreme Court case, jury. Yep, it's been a while since I released an episode of Supreme Court Briefs. You may be wondering, why haven't I? Well, to be perfectly frank, and to be perfectly matte, the series doesn't do that well. So if you want me to make more of these, share this video with everyone you know. And if the views are better for it, then I'll keep making videos for this series. It's that simple. Thanks for staying curious.